Good afternoon, and thank you for joining. Good afternoon on the East Coast. Good morning on the West Coast. My name is Eric Prager. I'm a partner in the New York office of Venable LLP. I'm a member of the IP Transactions group. This is a webinar on common ethics issues in IP transactions. A little bit about the scope of this presentation and what we'll be covering. Sorry, there we are. I noticed over the years that there are a lot of ethics programs that are designed for lawyers involved in litigation. And I didn't see a lot of programs that were put together that addressed the ethics issues that attorneys who are in more of a transactional practice commonly encounter, and specifically attorneys who are in a transactional intellectual property practice. There are a lot of overlap in the issues that are presented, but this is tailored specifically to some of the IP issues that come up and how they interface with the ethics rules. That's sort of the genesis of this program, and I have some submodules in it that I'll identify, and then we'll dig into them. So today we're going to cover what rules apply, what ethics rules apply, an admonition that I describe as beware the instructions you give. Out-of-state practice of law, we're each admitted in one or more states, but what happens if there's something going on in another state? The duty of honesty, attorney duty of honesty, communication with a represented party, conflicts of interest, and the duty to report misconduct. I'm going to focus this presentation on the New York rules, but they're very similar across the United States, and I'll flag some differences where they're germane and come up. But I should mention there's no substitute for consulting your own rules in the state where you're admitted to practice. They can vary, and you know, if there's an ethics issue, it's important and it's worth taking a look. So let's talk about what rules apply, and I will use some polling questions. And I'll ask you just to jot down your answer, and then I'll answer the questions. There isn't a sort of live polling function for the webinar, but we'll talk our way through it. So question number one, a lawyer is admitted to practice in New York State. What ethics rules govern her conduct today? Your choices are New York's implementation of the Model Code of Professional Responsibility, the one with disciplinary rules like DR 1-102 and ethical considerations. B, New York's implementation of the Model Rules of Professional Conduct, the one with numbers like Rule 8.5. Both of those. Or D, the Federal Rules of Professional Conduct. So take a moment to think about that, jot down your answer. Great, and we will move on. The answer is B, the New York implementation of the Model Rules of Professional Conduct. The one with the disciplinary rules and the ethical considerations was replaced in 2009. So those of you who were admitted to practice before that probably learned in your ethics course that prior rule set. I guess there's a remote possibility that there could be a conduct that occurred some time ago, although you'd have to imagine it would be time barred at this point. So I think it's pretty safe to say that B is the only correct answer to that question. Let's pose another question. A lawyer is admitted to practice in Illinois. He accompanies his client to a meeting in New York. Now, what ethics rules govern his conduct? Is it A, the Illinois Rules of Professional Conduct, B, the New York Rules of Professional Conduct, C, both, or D, another rule set that's not listed? So take a moment to think about that. And the answer is C, both. As we'll talk about, we're going to drill down into the rules a little bit, but as you'll see, both rule sets apply, both where you are admitted to practice and where you are actually practicing, assuming you have some basis to practice in that state, or if the state is enforcing your failure to have a right to practice in that state. There is a remote possibility that an additional rule set could apply depending on the conduct. There are court-issued rules and sometimes some other statutory rules. California has an additional code of rules. But generally speaking, the point we're trying to make here is that the model rules of the state where you're admitted and the state where your conduct occurs are both in play, and it's necessary to consider both of those rule sets. So as I just mentioned, New York adopted the model rules in 2009. Illinois, my example in the hypothetical, adopted the model rules in 2010. The last state to enact the model rules was California, and that was a few years ago. So now all states are on the model rules platform, although each state has its own variations or flavor of it. And I know there are a number of in-house counsel who are attending the program as well. All of the ethics rules apply to in-house lawyers too, including those relating to conflicts of interest, which we will get to later in the program. It's an important part of the evaluation. So here's the rule that underpins that. A lawyer admitted to practice in this jurisdiction is subject to the disciplinary authority of this jurisdiction, regardless of where the lawyer's conduct occurs. So if you're admitted in New York, the New York rules travel with you where you go. A lawyer not admitted in this jurisdiction is also subject to the disciplinary authority of this jurisdiction if the lawyer provides or offers to provide legal services in this jurisdiction. So that's our example of the Illinois lawyer traveling to New York. And New York says, even if you're not admitted in this jurisdiction, you are subject to our disciplinary authority if you're providing legal services here. And then finally, just to make the point abundantly clear, a lawyer may be subject to the disciplinary authority of both this jurisdiction and another jurisdiction where the lawyer is admitted for the same conduct. So it is possible to have a censure or other proceeding in multiple jurisdictions. Notably, that version of the rule that I just gave you is the model rule. The New York version of Rule 8.5 is missing this middle sentence that's struck out. There is no indication that New York believes it is relinquishing its authority to discipline lawyers who are admitted in another jurisdiction. I have not seen a decision on this, but my expectation is that New York simply considers the matter unlicensed practice of law and subject to disciplinary authority on that basis, regardless of whether the person is a lawyer or is not a lawyer. This is not, you shouldn't read this as a waiver of New York's enforcement authority. I don't believe that's the case at all. So as a practice tip, prospectively, if you are in a situation where there's a possibility that more than one rule set might apply, you should assume that the most restrictive rule set applies, the one that is most likely to prohibit the conduct, because if you go with the more permissive rule set, you may be coming up short on the more restrictive rule, obviously. So that's why it's important to think about these issues and make sure that you govern your conduct accordingly. Retrospectively, of course, if someone is already subject to a disciplinary review, counsel defending the lawyer might try to argue that one or the other rule set had a greater influence on the forum, or the lawyer understood one to apply and not the other, or whatever arguments lawyers make. But on a prospective basis, if you're trying to avoid liability, assume the more restrictive rule applies. So that brings us to the next segment, beware the instructions you give. And the relevant rule here is Rule 8.4, which is called Misconduct. And there are several subparts to it. And I'm going to flag two of them for our discussion, but take a look at the rule if you have occasion and see the rest of them. The rule says a lawyer or firm shall not violate or attempt to violate the rules of professional conduct, knowingly assist or induce another to do so, or do so through the acts of another. And what's more, a lawyer or firm shall not engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. So let's apply this in action. Polling question number 3. A lawyer for XYZ company filed a patent infringement case against his client's competitor, ABC Inc. XYZ noticed the infringing product recently, but thinks ABC has sold it for some years. The lawyer asks his contact at XYZ to call ABC's customer service line and ask when sales of the product began. Is this okay? Your choices are A, no, the lawyer can't call a represented party to gather information and can't ask his client to do it. B, yes, the lawyer is entitled to gather any information that ABC gives out to the public. C, yes, but only if XYZ does not lie about its identity when calling. Or D, oh no, I violated this rule last week. Please give a little thought and make your selection, and then we'll talk about the answer. Great. So the best answer is B. Yes, the lawyer is entitled to gather any information that ABC gives out to the public. There's a line of cases that started with a Southern District of New York case called Kita v. Campanello Imports that established or codified in modern usage the principle that investigations are okay. You're allowed to do investigations of publicly available information of what an adversary is doing in the marketplace. And as IP practitioners, particularly IP litigators, but IP practitioners generally, this is something you come across all the time. You need to know when someone began use of a trademark. You need to know when a product was launched and so forth. It is technically a correct answer to this question. Some of you who may have said C, only if XYZ does not lie about its identity when calling. That would be true if the contact at XYZ were a lawyer and him or herself were not permitted to misrepresent identity in gathering the information. So that could be true. Or if the lawyer told the contact, you should make up an identity, or you should misrepresent who you are when you call. Typically, when IP lawyers work with trade investigators, the trade investigators, you tell the trade investigator what you want. You don't tell the trade investigator how to gather the information. And the trade investigator often says, I approached the target, under a suitable ruse and gathered the following information. And that's fine as long as they're not a lawyer. They can use any ruse they want. They're not restricted to this duty of honesty that we as lawyers are subject to. Out-of-state practice of law. So Rule 1.5 governs out-of-state practice of law, and it says that a lawyer shall not practice law in a jurisdiction in violation of the regulation of the legal profession in that jurisdiction, or assist another in doing so. And it continues, a lawyer shall not aid a non-lawyer in the unauthorized practice of law. So this is the New York rule. The New York rule has these two parts, A and B. The model rule and the rule in force in other states that have adopted different versions of the model rule also has subparagraphs C and D, and they expand the range of who can practice in the state. Practice of law conducted with a lawyer who's admitted in the state, practice under a pro vice admission, practice that is reasonably related to the lawyer's practice in a jurisdiction in which the lawyer is admitted to practice. That's a nice one. That is, you can accompany your client on a meeting out of state and not have fear that you're running afoul of the rules in that state. In-house practice on behalf of an employer, and we're permitted under federal law. So think about patent agents who are in effect practicing law, but are permitted to do so, at least with respect to issues involving patent prosecution. So these are great to haves, obviously, and what are we to conclude by the fact that that these are not included in the New York rule? These are, in the context of New York, I would describe them as sort of historical artifacts of how the rule got enacted. There isn't really any question that you can't practice in New York under a pro hoc vice admission, or if you associate with a lawyer who is admitted to practice, or practice on behalf of an employer. Some of these are governed by court-issued rules in New York. And certainly Pro Hoc Vice admission and association with another lawyer, there are court-issued rules in that regard, and practice on behalf of an employer. So you do need to look to some other authorities for those. You can rest comfortably that these are likely to be included in New York. If there were ever, I have not seen a case that really took to the nth degree, the reasonably related to the lawyer's practice in a jurisdiction where the lawyer is admitted to practice. It seems to me if there were going to be a dispute, it would be something turning on whether the extension of the practice was reasonably related, and I imagine there could be a dispute about that at some point. But those seem to be rare cases. They certainly don't come up regularly. They're not easy to find. So, practice tips. In-house lawyers and registered patent agents have express coverage under Subpart D, and in New York, they don't have express coverage in the rule set, but there are court-issued rules. Business people who are lawyers should exercise caution. Are you practicing law? And if you are practicing law, are you practicing law in a state where you're admitted? There are some industries, the music industry, for example, where many executives happen to be lawyers. They moved into the executive ranks out of the legal department, but nonetheless are lawyers, keep their admission active, and are subject to all of these rules. So those folks need to be particularly careful and consider, am I giving legal advice? Am I acting as a lawyer, or am I acting as a business person? Do I expect privilege to attach? This can be important when considering what kinds of statements you can make. Like, for example, if you're a lawyer, you may not be able to do that trade investigation if you need to misrepresent who you are in order to get the information. That's important to keep in mind if you happen to be a lawyer but aren't practicing. It's worth being mindful of these rules when you're negotiating in other states. If you have a significant transaction and you're going to be negotiating in other states on a frequent basis for a little while the deal is going on, you might want to think about these rules and make sure that you're dotting I's and crossing T's on them, that you have a theory of why you're allowed to practice outside of your state. And be mindful as well of choice of law provisions. If I have an agreement that I've been negotiating for 6 weeks and it's been governed by New York law, and in the final horse trading at the end of the negotiation, it gets changed to Delaware law and I'm not admitted in Delaware, I need to be careful that I'm not representing that I'm giving advice on Delaware law. I may not be practicing in Delaware per se, and perhaps this is more of a malpractice issue than an ethics issue. But certainly it's important to be mindful of whether you are giving advice with respect to the law of a state where you're admitted. And if there's a limitation on that, you would be, I think, well advised to get clear with your client on that. Send your client a note saying the other side changed the choice of law to Delaware. I'm not admitted there. If you'd like me to get an opinion on this from one of my colleagues who is admitted in Delaware, I would be happy to do that. That's that quick email exchange on that is a good safety valve against having a problem later. So let's talk about the duty of honesty. The rule is 4.1, and it's called truthfulness in statements to others. And the rule provides that in the course of representing a client, a lawyer shall not knowingly make a false statement of fact or law to a third person. This is a different from everyone else in the business world. Other folks in the business world don't have this restriction on them. There may be limitations on misrepresentation that gives rise to a misrepresentation cause of action, but that's a much higher threshold than a false statement of fact or law. And when I've given this presentation historically, I sort of observed here that as lawyers, I'm not sure whether we should be proud that we hold ourselves to a higher standard, or whether we should be embarrassed that it was necessary to make a rule about this. But either way, you should be aware that as a lawyer, you have a different obligation in terms of the statements you can make in the course of representing a client. So the model rule, I showed you the New York rule, which I'll go back up to here. Lawyers shall not knowingly make a false statement. The New York rule is that language that I showed there. The model rule is that a lawyer shall not make a false statement of a material fact or law. What do we infer from that? Or do we infer that in New York, we are going to be even more strict about this rule? And I think the answer to that is that New York wanted its Character and Fitness Committee, which is the name of the committee that handles ethics and bar admission issues, wanted to give them the flexibility to decide on the materiality. I think it goes to what the remedy is probably as much as anything else, rather than the violation of the rule. And New York also omits paragraph B that is in the model rule and is in effect in a number of states. And part B is that a lawyer in the course of representing a client shall not fail to disclose a material fact to a third person when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client unless prohibited by Rule 1.6. And this may bring to mind some of the discussions that I remember from law school learning this stuff. The issue of when you're required to withdraw from representation. For example, if you can't disclose confidential information, but you think there may be criminal or fraudulent activity, you might need to withdraw. And then there's the question of whether you need to make a noisy withdrawal or whether you can silently withdraw. If you ever find yourself dealing with that kind of a situation, get counsel on it. If you're in a company or a firm and you have in-house resources available to you, that's great. Talk with them about it. If not, I'm an IP lawyer with an interest in ethics, but there are ethics lawyers. And if you find yourself dealing with this kind of a situation where you're potentially at risk of assisting in a crime or a fraud, you certainly want to get counsel, not just to tell you what the right thing to do is, but also to be able to say that you got counsel. You acted on the advice of counsel. That will go a long way if you do end up on the wrong side of it somehow. And California, in enacting its new rule set in 2018, for the first time added this duty of honesty, which, arguably there was some duty of honesty previously, and certainly I'm sure any judge in California would tell you there's a duty of honesty to the tribunal. But for what it's worth, California, in enacting the model rules in 2018, first enacted this. I should mention, I see a couple of Q&A questions are coming in, and if it's all right with all of you, I will. I'm going to wait till we're a little farther into the material, because I do want to make sure that I get through as much of it as we can, and then I will circle back and talk through that a bit. Continuing with respect to the duty of honesty, so. Patent lawyers and patent agents will know that that there's a patent bar exam. You get admitted to the patent bar, and attorneys and agents who are admitted to the patent bar are also bound by 37 CFR section 1.56, or as the patent lawyers call it, Rule 56. And Rule 56 says that there is a duty to disclose information material to patentability when you're acting before the patent office, and that rule says each individual associated with the filing and prosecution of a patent application, and that's each individual associated, so that's both the lawyer and the client, has a duty of candor and good faith in dealing with the office, that's the Patent and Trademark Office, which includes a duty to disclose to the office all information known to that individual to be material to patentability as defined in this section. However, no patent will be granted on an application in connection with which fraud on the office was practiced, or attempted, or the duty of disclosure was violated through bad faith or intentional misconduct. So what does that mean? Well, that's super important to transactional lawyers. This comes up in litigation all the time. There's hardly a patent infringement case that doesn't include some kind of allegation of a misrepresentation in prosecution and an allegation that the patent is invalid as a result. But what does that mean for transactional lawyers? Well, for transactional lawyers, that means that the assets that you are evaluating, the assets that you're considering, patents that might be licensed or sold, might be unenforceable if there was some kind of misrepresentation to the patent office in the course of procuring the rights. So that means that whether there was any sort of misrepresentation is absolutely a fair subject for due diligence. You need to know, especially in a high value transaction, you certainly need to know whether there was any sort of misrepresentation, something that the inventor or the inventor's counsel knew that wasn't disclosed. And obviously if you are a third party purchasing those assets, there are privilege considerations and a number of issues you'll need to work your way through. But the bottom line is Rule 56 will make your patent asset that you're paying a lot of money for invalid if there was any sort of misrepresentation. So you are going to have to deal with this issue or deeply discount the asset to account for not knowing the answer. What I've done in these situations where these issues are in play in a significant way is kind of stage the diligence so that these kinds of conversations, interviews with the inventors, interviews with counsel, happen late in the process when it looks like a deal is likely and we're sort of doing our final close off. I guess theoretically you could do some kind of a holdback, although that seems maybe more complicated than it needs to be. But these are certainly valid issues, and don't let anyone tell you that they're not. These go to whether you're actually getting what you think you're getting in the transaction. You should be aware that not every statement that is untrue is a misrepresentation. There can be puffery that's not actionable. It's very different to say, the price for this transaction is reasonable because this is the best widget on the market. That's puffery, and that's different from this transaction is a good deal for you because this widget is twice as fast as any other widget on the market. That is a quantifiable statement that's no longer puffery. And the Rule 56 issues you should be aware as well. Although 37 CFR 1.56 doesn't apply to the trademark side of the Patent and Trademark Office or in the Copyright Office, decisional law has pulled in the same considerations. Patent law has sort of led the way on this, and trademark and copyright have followed in imposing very similar requirements. So trademark registrations that are procured through fraud are also going to be subject to cancellation, and likewise for copyright registrations. Let's switch to communications with a represented party. So this one we're all sort of familiar with, but may not have thought of exactly how it plays out in the context of transactional work. So the rule 4.2a says that in representing a client, a lawyer shall not communicate or cause another to communicate about the subject of the representation with a party the lawyer knows to be represented by another lawyer in the matter, unless the lawyer has the prior consent of the other lawyer or is authorized to do so by law. And the ABA comment number 3 to Rule 4.2 says that this rule applies even though the represented person initiates or consents to the communication. So let's take a example, and then we'll talk a little bit more about the rule. Polling question number 4. Boyfriend sues his former girlfriend. At his deposition, his lawyer leaves the room during a break. Boyfriend asks girlfriend's lawyer how she's doing. The lawyer says he's concerned about the toll that the case is taking on her, and he's sure she'd be better if the boyfriend dropped the case. So what could happen to the lawyer, assuming he has never been subject to sanction previously? A, it depends whether the boyfriend acted based on the lawyer's comment. B, nothing, regardless of whether the boyfriend took any action. C, the lawyer could be formally admonished. Or D, the lawyer could be disbarred. So take a moment to think about that, and then I'll give you the answer. So the answer is C. I guess maybe the lawyer could be disbarred, although that's why I added the piece about the lawyer not having been previously subject to sanction. I know that C is the right answer because this is a real case. This happened in Massachusetts, and the lawyer was formally admonished on this fact pattern. So be aware that these kind of, even a glib off the record comment, if it's a represented party, you need to be very careful. Now, let's talk about how this applies in the context of transactions, and in particular IP transactions. So this comes in my practice, this comes up somewhat regularly in deals where I am working with a client, and the folks on the other side of the deal have a business person and a lawyer. And oftentimes it happens when there are more than just the four of us. There are a whole bunch of people involved, and there's some struggle to get the calls together, and people sometimes need to come in late or leave early. And once you know that there's a lawyer working on the deal on the other side, that lawyer needs to be on the call. You can't get on the call as a lawyer. You can't get on the call with your client, have the business person on the other side get on the call and say, my lawyer, Lisa, is running late. I walked by her office on the way to the conference room here, and she said we should start without her, and she's going to join us as soon as she can. To my comfort level, that's not good enough. That is the client on the other side saying that it's okay, not the lawyer on the other side saying it's okay. So what do you do about that? What I do about that is I send an email to the lawyer and I say, hey, your client jumped on the call and said you're running late. Is it okay to start without you? And if the answer comes back yes, we start. And if the answer doesn't come back at all, we wait and possibly reschedule. And that's just how that goes. So if you have someone floating in and floating, I call these people floaters, you have people floating in and floating out sometimes, get that permission up front for the rest of the calls. Look, we're going to have more calls on this. If you're not going to be able to make some of them, is it okay to start if you're not there? And I've certainly had situations where lawyers have said that's fine. You know, that no one is going to be bound by this until there's a final agreement and everyone signs it. And you know, I'm not worried about that. That's fine. Just get an email to that effect so that you can't get sideways on it. You know, no one's going to complain about this while you're negotiating or at the end of the phone call. The way these things are going to come up is something goes hard. The deal is signed. Something goes horribly wrong, and one party wants to get out of the deal or claim there isn't an agreement or who knows what, and then they're looking for things that went wrong back in the process. And that's when things like this come to a head, and you can prevent that by getting that simple email. As I mentioned, only the other side's lawyer can waive the obligation. Investigations are excluded, subject to the caveats that I mentioned earlier. And be aware as well that some communications don't relate to the subject of the representation. You know, certainly you want to be careful. You don't want to get sideways on this. But you know, if the other side's business person, you know, wishes you happy holidays, you're certainly entitled to respond with a happy holidays. It doesn't relate to the subject of the representation. So it's not every communication, but you know, you don't want to be arguing about that point if you don't have to. So I'm going to actually take a moment and take a look at some of these questions now and see if I can answer some of these. So this is a good question. I'll read it. So a solo trademark transactional attorney is admitted in California, occasionally practices from a part-time home office in Nevada, but is not admitted in Nevada. The attorney does not meet with clients or third parties in Nevada. Inasmuch as the practice remains the same in both locations, would the attorney be subject to Nevada ethics rules? Boy, that's a tough question nowadays. And I would be uncomfortable making a definitive pronouncement as to Nevada or California law on that. But I would say it's worth some research. A lot of bar associations or committees of bar associations, ethics committees of bar associations, have been considering these issues of remote practice over the last year and a half, and I think that that's something that you'd want to look at. Obviously, this isn't going to come to a head unless something goes horribly wrong. So there will be an incentive, and there will be some pressure probably for Nevada to do something about it. That's how this would come to a head. So I think you do want to be careful. I think you do want to find some kind of a loop for that. Analogizing it to the pre-pandemic practice of law, it's certainly the case that if I'm on a business trip in Washington, well, I happen to be admitted in Washington, so that's a bad example. If I'm in a business trip in California where I'm not admitted, and I receive a phone call from a client of mine in New York, and I take the phone call and I'm giving advice. Am I practicing law in California? Maybe, I don't know. What makes this question a little different for me is that there's a home office. So there's a persistence to the other jurisdiction. And I think for that reason, you want to exercise some extra care on that. So I think it's a very good question, and I think it's particularly germane as to the current landscape that we're all working in. Okay, so let's move on to conflicts of interest. It might surprise some in-house lawyers to hear that conflicts of interest rules apply to them also. We all know that they apply to outside counsel, and most firms have a robust conflicts clearance system. In-house lawyers may not think about these issues as much, but there are some good reasons why they should, and we'll talk a little bit about that. And before we do, I'm going to give you the CLE code that you'll need to get credit for this. So I just want to make sure that you have that to get your credits. The CLE code is IP ethics. So on to conflicts of interest. Rule 1.7. I'm going to sort of move somewhat quickly through these rules because there are a lot of them, and the slides will be available, and I don't think you need me to read all of them to you, but there's some framework to this that I think is worth us discussing. So 1.7, conflicts of interest, current clients. So except as provided in paragraph B, a lawyer shall not represent a client if a reasonable lawyer would conclude that the representation involves the lawyer in representing differing interests, or there's a significant risk that the lawyer's professional judgment would be impaired by the lawyer's own financial interest and so forth. So this is except as provided in B. B, notwithstanding the existence of a concurrent conflict, a lawyer can still represent the client if, and then there are 4 requirements to meet. Now, if you work at a firm, or if you're in-house, if you work at a firm and have conflict waiver letters, or if you're in-house and receive conflict waiver letters, these 4 subparts are commonly part of the text in those waiver letters. There's a statement typically that the lawyer reasonably believes that the lawyer will be able to provide competent and diligent representation of each client. The representation is not prohibited by law. The representation doesn't involve assertion of a claim by one client against another client in the same litigation or before a tribunal. That's an important one because that is a non-waivable conflict. And 4, each affected client gives informed consent confirmed in writing. It can be email, but it does need to be confirmed in writing, and it needs to be informed consent. You need to have provided the client that's giving the waiver, each client, enough information to enable them to give informed consent. So, so be aware of that when seeking the waiver. And then there are some specific rules for current clients. And this is a rule relating to entering into business transactions with a client. It is, I think, relatively common for a lot of lawyers to hear requests from clients, often smaller clients, encouraging the lawyer to take an ownership interest. Can I give you equity instead of paying cash for your services? There are rules about this, and you need to comply with them. I'm not going to read through all of 1.8a, but we'll make slides available, and you can take a look for yourself. 1.8 has a subsection F, which is similar to 1.7b, which says that the client has to, again, give informed consent, and has the further requirement that there's no interference with the lawyer's independence of professional judgment or with the lawyer-client relationship. And it's easy to understand how it is not uncommon for owners of companies and companies themselves to have differing interests, for shareholders and companies to have differing interests. And as a lawyer for the company, you can't get in a position where your own economic interest is adverse to the interests of the company you're representing. So if you're going to have an interest, it needs to be in a way that avoids that problem. So you'll want to consult counsel or do your research or otherwise satisfy yourself that you're able to do that. And that information relating to the representation is protected pursuant to Rule 1.6. So that's F. There's a specific subpart G that provides that a lawyer that represents two or more clients can't participate in an aggregate settlement of claims as between the clients, or in a criminal case, or a guilty pleas, unless each client gives informed consent. And there are additional disclosure requirements. So be aware that there are specific rules where you're representing two or more clients. This happens, regularly. It's not uncommon for there to be joint defense agreements, for a lawyer to take, if a lawyer represents a client that sold something and both the customer and its own client got sued, or only the customer got sued, you continue to represent your client who got you into this, and also perhaps the client that you're providing a defense to. Be careful of these rules. We obviously can't go through every permutation of this today, but understand there's a rule and you need to take a look at it. And then 1.8I, further information about requiring or requirements around getting a proprietary interest in the subject matter. This too can come up in relation to litigation finance, and this is these are again somewhat complicated structures and require some attention. And for purposes today, it's worth being aware that you need to dot your I's and cross your T's on this. And then there is under the conflicts rule a prohibition on sexual relationships between lawyers and clients, and it applies within law departments. It applies within firms, and it's something to be aware of if you find yourself in a situation where that kind of a relationship may develop. It's worth making sure that you're compliant with the ethics rules. And finally, 1.8J, whenever there's a prohibition with respect to a firm, the prohibition applies to the entirety of the firm. we all, I think, remember that from law school, but it's worth a mention that these are throughout the enterprise. So, some practice tips on this. Whenever there is a risk of a conflict, get a waiver. There's no harm in getting a waiver where a waiver wasn't needed. You know, if there's a close call, get the waiver. I don't mind getting waivers. I actually, particularly where I'm representing someone else, the waiver can communicate that I'm active. We're active in this space. I have a number of clients in this space, and know what I'm doing. And there's I think there can be. You're not just complying with the rule. I think it's not necessarily a bad thing to have folks know that you have this breadth of experience and other clients in the space. Patent lawyers need to be careful about their disclosure obligations under Rule 56, and the reason for that is you have this duty of candor to the patent office. You're required, for example, to disclose the prior art that you know about that might be material to patentability. But what if the prior art you know about is prior art of another client, and that prior art is non-public? The other client has it in its own patent application that's not published yet. That's a tough situation to get into, and the way we try to address that here at the firm is for new patent application matters. We have an additional level of conflict review where we review the subject matter in addition to just the parties, and try to avoid getting into situations where we might have knowledge that puts us in that difficult position of having to decide between those two rules. Pay attention to the scope of the waiver. Again, it's an informed waiver, and if you're not informed, the waiver may not be effective. So you need to be cautious of client confidentiality, but you also want to make sure that the waiver you're getting is doing its job for you. And I mentioned when we were back at 1.7b that litigation conflicts are not waivable. I think folks remember that, but it's worth a mention as we're talking through it. And then finally, this is our last rule, and then after we talk about this, I'll take a look at the remaining questions and field any additional questions that you all have. Rule 8.3, the reporting of professional misconduct. Rule 8.3 says, a lawyer who knows another lawyer has committed a violation of the rules of professional conduct that raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness as a lawyer, shall report such knowledge to a tribunal or other authority empowered to investigate or act upon such violation. So a duty to rat out your professional colleagues. It's maybe not as broad as it sounds, but it's a very important rule. So it's only triggered when the knowledge that you acquire is knowledge that raises a substantial question as to the lawyer's honesty, trustworthiness, or fitness as a lawyer. So it's not de minimis. It is a substantial question, and honesty is covered. Fitness as a lawyer, there could be a situation where someone has a personal crisis that gives rise to questions about their fitness as a lawyer. You might have a duty to report it. And as I mentioned earlier with some of these close calls, there is an entire bar of ethics lawyers, and this would be a good situation to consult with one. If you are going to report someone, at least for my personal comfort, I would rather have talked with a lawyer who's an expert in the field first. Maybe I get advice of counsel that I don't need to report it. Maybe I get advice of counsel that I do need to report it. And in that case, I have a very good answer if someone complains, well, why did you report this? Well, my lawyer told me I should. So that's a good opportunity for that. Also, the rule specifies that this obligation arises when a lawyer knows of these conduct missteps, and shall report such knowledge. It's not if you have an opinion, it's not if you have a concern, it's if you know. Again, if you really think so, but you're concerned, maybe you don't know, again, get advice on it. Another thing you can do, and I put in the third bullet here, another thing you could do is you could ask the other lawyer, if you think you need to report it, you could ask them, why don't I need to report this? I'm concerned that I might have to report this, that I could be in violation of the rules because I didn't comply with my own duty under Rule 8.3. I shall report this, it says. Why don't I have to do that? And maybe there's a good answer. Maybe there's a good answer. Obviously, this is a touchy one and needs to be handled carefully. But it's clearly in the rules, except in California. This was not a rule that California enacted in 2018 when it adopted its rules. I haven't seen a case in California that imposes this obligation in some other way outside the context of actually a crime or a fraud, but worth a look. I'm going to take a look at our other questions. Okay, I think we are caught up on the questions. This would be, if you've been holding questions in reserve, this would be a great time to offer them up. So I'll give you a moment to do that. And we're not seeing a ton of them roll in. So we are at 5 minutes before the hour. So I guess what I would say in closing, and I have obviously taken a subset of the applicable rules, just sort of highlighting some that I think are interesting in transactional practice. When you go back and take a look at the rules, especially after having practiced for some years, at least for me, it's an interesting exercise because you see the practical application of a lot of these things in a way that you may not have when you were in law school and first taking this. And examples jump out at you, life experience jumps out at you, and it sounds sort of dorky and maybe even boring, but it's kind of an interesting read, I will tell you. I would commend you to take a look at the rules, and I'm always happy to discuss these issues. So feel free. Let me go back to the slide that has my. Oops, I'm out of. There we are. My contact information is there. Don't hesitate to shoot me a note or give me a call. These are interesting issues, and it's interesting to have practice experience that informs how the rules apply. And if you come up with some good fact patterns, I would love to hear about them, and we can negotiate a license for me including them in the materials for next time. So thank you for joining, and we will see you next time.